Hear you, hear you, hear you. Well, you said it many times in one second. Okay, I'll do the way Colorado, Daniel Escarabia, and providing animal with all the
Well, good morning, everyone. Great to see you. I am Michelle Rick, and I'm really delighted to be joined by my colleagues, Judge Allie Greenleaf Maldonado and Judge Dan Karabkin. Today is day 2 of our panel. We are panel 5 here in Grand Rapids for the October call. And just a couple of comments. We've read everything, and I mean everything. If it was submitted, it has been read probably several times by several people. And I say that so that you are aware we are familiar with each one of your cases rather intimately, probably not as much as you, but close. And so, you know, you can rest assured if you focus on your legal arguments and the questions that we have for you, you should be good to go. We do have several matters with complaining witnesses, child victims, etc. Anyone of a precious category. If you could kindly refer to them by their initials rather than full names. We have a couple of matters that we are going to take by Zoom, but we're going to get started with those in the room here today, which means we're going to start with item number 17 on the docket. And before I invite counsel to approach on that, the only other thing I will add is I'm not so much a stickler about your time of your arguments. I'm going to keep somewhat track of it, but if you'll let me know if you are the appellant that you want rebuttal time, we'll probably keep a closer eye on the timing. But for the most part, we know you're here, that your clients are dependent upon you. We may have questions, and it should be an engaging session all around. So with that, I will call item number 17 on the docket, which is docket number 372611, People versus Charlie John McKay. Good morning, everyone. Hello.
Good morning, Your Honors. May it please the court, Marissa Vinsky and Mary Chartier of Chartier and Yampakudza on behalf of Charlie McKay. May I please reserve 2 minutes for rebuttal?
Absolutely. And is Miss Chartier weighing in at any point, or are you doing it solo?
I am doing it solo.
All right. Please feel free to proceed.
Thank you. Nobody is denying that a tragic accident happened here, but that does not excuse the government's burden of probable cause to prove the necessary elements that they needed to. The district court should not have bound over Mr. McKay after the preliminary examination for the following reason. There was not sufficient evidence to prove under a probable cause standard that Mr. McKay was under the influence of alcohol or controlled substance. The jury instruction for determining whether someone is under the influence is clear. Having drinks beforehand is not enough. The smell of alcohol is not enough. What we have here is a receipt that Mr. McKay purchased alcohol beforehand, and we have an officer who said that she smelled intoxicants coming from Mr. McKay. But when looking at his physical and mental condition, which under the jury instruction one must do, there is not probable cause to show that he was significantly affected by alcohol or marijuana. The evidence shows that he was not affected. There was no evidence that he was deprived of clearness of mind, self-control. Each of the witnesses that were called at the preliminary examination who had contact with Mr. McKay, not only before, but also after the accident, agreed he was walking fine, he was talking fine, he had no dexterity or motor issues. And this is actually after being involved in a serious accident where one would expect someone to be shaken up. There's no other symptoms of him being intoxicated. He was able to answer questions. He was able to exercise his rights to do things, not do things. He was able to understand them. He carried on conversations. Of import, the other driver's BAC was 0.2. So there was actually clearer evidence of his intoxication at the preliminary exam than there was of Mr. McKay's intoxication.
But both had alcohol in their system.
Correct, but per se, Mr. McKay is not under the influence because his was only 0.05. So that is correct, Your Honor.
And the jury instruction allows for an alternative to the per se.
That is correct.
So why doesn't the fact that there is alcohol in the system of both drivers, and we have a fatality and we have accident reconstructionists who weighed in, why doesn't that create a triable issue? Why doesn't that rise to the level of probable cause that something illegal happened and that your client may have some culpability?
Well, and didn't Mr. McKay also have marijuana system? So he had 0.51 BAC plus the marijuana. I mean, to me, that gives that should go to the jury to determine, especially with the accident reconstruction.
So 0.051 was the alcohol content.
0.05, sorry.
Yeah,
0.51.
that's okay.
Right.
And 2.3 nanograms. And as the court has determined, there's no per se amount of marijuana in someone's system that would enable them to be intoxicated. So you, again, have to look at clearness of mind, how the person is acting. You can't just take, okay, this person has alcohol and marijuana in their system. If that's the case, then the jury instruction would be moot. The jury instruction would be moot that you can consider this other thing. And quite frankly,
but the jury instruction is different than probable cause. So-
correct. And even at that standard, the accident reconstructionists could not opine about Mr. McKay's behavior. They weren't able to see him before the accident. They weren't able to see him after the accident. While they may have been able to determine cause, they have no information whatsoever about the intoxication level. And I think there was a question of cause, whether Mr. McKay was the cause of the accident. Again, that's not what we're challenging. That can go to the jury, but they had no information whatsoever about his intoxication level. And I do think we have the benefit of the Ellenwood case. I know the government has said that's different, but I believe it's extremely persuasive. In that case, the defendant looked down while he was driving. He crashed. The court determined that looking down is not per se someone being intoxicated. That wasn't caused from them having marijuana in their system. In this case, there was evidence on the record that Mr. McKay saw headlights oncoming. He could not avoid them. The court couldn't determine that that was from intoxication, even by a probable cause standard. There was dark lighting in both cases, difficult viewpoints. This accident happened at a sharp S-curve. I think multiple witnesses testified about that. So again, the core substance of this, whether Mr. McKay was under the influence, whether he was of clear, sound mind, whether it impacted his ability and physical condition to be able to operate a vehicle in a normal manner, that was not proven by a probable cause standard. And I know the court has read all my briefings, so I'm happy to answer any questions that you may have, but we would ask the court to reverse the district court's bind over and the circuit court's denial of the motion to quash.
Thank you,
Thank
counsel.
you.
You have
Thank
plenty
you.
of time for rebuttal.
Thank you.
Morning, Your Honors. Audra Blodgett on behalf of the Kent County Prosecutor's Office.
Good morning.
I will also be largely resting on my brief, but the main point I would emphasize before you this morning is that we agree there are questions of fact, but that is not the district court's job at Bindover to resolve these questions of fact. That is a job for the jury. There are conflicts of evidence. There's evidence that weighs in favor of defendant's case, Again, it is not the district court's job to weigh the evidence to determine the likelihood of conviction. That is the job of the jury. It was the district court's job to determine if there was evidence, including circumstantial evidence, of each element of the charge. And I know there has been pointed out this morning the evidence that weighs in favor of defendant, but contrary to their argument, there is evidence of intoxication and driving under the influence in this case. There's an admission to drinking alcohol just prior to driving. There is a strong odor of intoxicant noted by a law enforcement officer 1 hour after the crash. An officer qualifies Mr. McKay as confused on PBT instructions. 2 experts say he crossed the center line. And although a lack of normal driving by itself is not enough to establish this charge, it is in the totality of the circumstances relevant to whether he was impaired by alcohol.
He also lied, which is a sign of guilt.
Exactly. And we did cite that and support it with the case law that says as much. He denies drinking when he first asked by the officers. A lay witness who was at the scene says he appeared to have crossed the center line. A witness says the victim was not driving erratically. The victim was visible. The victim was driving with headlights on. So although there is conflicting evidence, the evidence that I just listed, I think is more than enough to meet what this court has said is a low standard probable cause in this case.
Can I ask about the low standard? What I was trying to think through is, well, maybe you could help me. If we were reviewing all of this evidence after trial on a sufficiency of the evidence standard, would that be a different standard?
I think it would be a different review in that, you know, all of the evidence would be seen on the prosecution's behalf, to be in the light most favorable to the prosecution. But you still would need evidence that meets each element. So I think in that regard, it would be largely the same. But
I guess maybe back up a minute and just, I guess what I'm trying to ask is if this were the trial record, would you be taking the same position that there's enough evidence to convict? Or are we even at a lower standard than that, which is enough evidence to go forward?
We're at a much lower standard now, just the probable cause standard. I think, you know, I would have a much higher hurdle to cross for proving beyond a reasonable doubt. I think there is enough evidence here and evidence that has been developed along the investigation since bindover that would be presented at a trial. But the prosecutor's office wouldn't be proceeding with the case that we didn't think we could prove beyond a reasonable doubt. So my position would be the same, that this is a meritorious case. And not only is it meet the probable cause standard of bindover, but this evidence and more evidence to be presented at trial will be sufficient for a beyond a reasonable doubt standard.
Anything else?
That's all for me.
All right.
Thank you
Thank you very much.
Thank you.
We've got 2 minutes of rebuttal.
Be very brief. I just wanted to target 2 areas. While Mr. McKay did ask clarifying questions during the PBT, I think that actually shows that he was following along. He asked a question, so like I suck in like a straw. That shows he was following along with what he was supposed to be doing. Asking a clarifying question does not indicate that someone was intoxicated. Further, I would assert that lying does not indicate that someone was intoxicated. While it may go to guilt of whether he drank beforehand, which again, it's not a strict liability offense. Someone drinking and having alcohol in their system, someone having marijuana, there was no evidence he even smoked that day or ingested marijuana at all. But it's not a strict liability defense to have those substances in your body. So lying about whether you drank beforehand does not go to intoxication, which is what we're challenging today. Thank you.
All right. Thank you all. This matter is submitted. We'll see you next time. Thank you.
Enjoy that beautiful weather.
It's chilly today.
We are taking item number 18 next, which is docket number 372136, People versus McQuinney's Chantal Weed. Please. And did I pronounce your client's name properly?
Yes.
Okay, thank you.
Good morning, Your Honors. May it please the court, Tracy Gittleman for Miss Weed this morning. I know Your Honors have read the briefs. I asked the court, knowing that the court revoked probation and sentenced 9 months above the minimum of the guidelines, advisory guidelines. But given all of the surrounding circumstances, the sentence was unreasonable and disproportionate in its extent of sentencing within the guidelines for multitude of reasons that were brought out in the brief. But I argue that all of these factors that were not considered by the guidelines should be taken as a whole to form a sentence. And the court, even facing guidelines, at times it's reasonable not to sentence within the guidelines, but depart downward. This was one of those cases.
Well, that's a different standard. We're not deciding whether a different sentence would have been reasonable. We have to decide whether this sentence was unreasonable.
Okay, I argue this sentence is unreasonable based on the factors, because the factors that the court did not take into account, that were taken into account at the original sentencing, which is what framed the plea agreement, were very important here. Number one, she testified against the co-defendants and she received death threats for those. It's obviously a scary, horrible thought to know that you're going to go through life knowing you've testified against 2 people that you're going to put away for a long time in prison. And obviously she was given the benefit of that testimony, which didn't continue on with her probation violation. The probation violation was not serious.
She absconded.
She did abscond.
As a former trial court judge, give a lot of people a lot of leeway, especially when you issue, no cash bonds. And when they run, that's something you're allowed to take into consideration in the resentencing.
I 100% agree, Your Honor. 100% agree. That is a factor to be taken into consideration. However, I don't believe that Judge Trusock took into account the fact that what the probation agent recommended twice. Before absconding, the probation agent recommended the 9-month jail term.
Yeah, I mean, I think we'd be in a different situation had the absconding not occurred, right? I mean, if it was just the retail fraud and then
Right.
she gets resentenced on the guidelines for the underlying offense, that would be extreme. But she was gone for 2 years, and that's a pretty serious situation. And the case law seems to say you resentence on the underlying offense as opposed to the specific conduct that gave rise to the violation.
Well, if I may piggyback on that, and I'd like input from both attorneys. As I read the resentencing transcript, a concern that I had was obviously she testified and there were murder convictions of the co-defendants. The murder is not necessarily in dispute, but the judge's comment that you were involved in a murder and clearly could have been convicted of felony murder and gone to prison for the rest of your life. That to me, and things, I'm not going to read the whole quote, but that to me is concerning because it sounds like the resentencing is not on the convictions for which your client was convicted, but rather the offense that she was not convicted of, and that but for her testimony, the people would not have obtained convictions against the co-defendants. But could you drill down on that at all? And again, I want both of your input. I'm just being very transparent with you that That really bothered me reading that in the transcript.
Well, I agree, Your Honor. The judge didn't review or chose to ignore the undisputed facts that she had no idea that this was going to happen. This was a robbery that had gone bad. She didn't have anything to do with the actual murder itself. And she was screaming to stop. She immediately, she told the police exactly what happened. She was cooperative. She was not convicted of the murder. They reduced to her because they couldn't prove beyond a reasonable doubt.
Yeah,
Can
she had
you
assault.
remind me, was she charged with that? With, what were the original charges, please?
Originally charged, let me take a look at my brief here.
Thank you.
She was originally charged with open murder, yes. Which was dismissed.
As part of the plea agreement.
Correct,
Mhm.
correct. And there was another case that was dismissed, this 2018 case, but the judge did state in the sentencing at the probation sentencing that she knew that they were going to rob, and said that also you knew that he would be killed. Yes, and yes, she was not convicted of open murder, and he is in essence sentencing based on the fact that she was convicted of open murder. I mean, any other questions that I can answer?
Any other questions for counsel?
No.
No, I think we're all set. You have time for rebuttal.
Thank you, Judge.
Thank
Judge.
you.
Good morning, Audra Blodgett, Kent County Prosecutor's Office. I will largely rest on my brief, only to reiterate that this is a presumptively proportionate sentence. It is within guidelines, very close to the minimum guidelines.
What about Judge Trusak's comment?
I would,
Please address that.
yeah, focus on that since you have a question. So you clearly could have been convicted of felony murder and gone to prison for the rest of your life. The facts that would have established that comment would have been brought out in her testimony against her co-defendants. But
There's clear case law that says you cannot be convicted of offenses for which you have, or you cannot be sentenced for offenses that you have not been convicted of.
yes, and that is true, but there is case law that says a sentencing court may consider the nature of a plea bargain and charges that were dismissed in exchange for the plea for which the court is sentencing. So that case was dismissed against her. She received the benefit 1 year in jail for a felony murder charge, unarmed robbery, assault with intent to murder, and 5 years of probation. So although he is now considering the fact that she was involved in a felony murder circumstance, the circumstance of the offense and the offender for which he is allowed to resentence her for her probation violation, I think that is supported by the case law that says that he can consider that in fashioning her sentence. And I would point out that although the argument is he is not taking these into consideration, the fact that she pled, that she cooperated, I would argue that there's evidence he did. 9 months above a minimum sentence. So obviously he didn't think it was a top of the guidelines probation violation. I would say there's evidence that he took into account her history of cooperation, but also then sentenced her within her guidelines for absconding and then committing another crime in a different state. She was arrested on drug charges in South Carolina. So not only did she commit a retail fraud in Michigan, but then continued to commit criminal offenses while she was absconding and then brought back to Michigan to be sentenced for the sentence she knew was on the table when she entered into this plea agreement. I don't think there are any unusual circumstances that would render this low guideline sentence disproportionate, rare, or unusual.
No other questions, counsel.
Very
Thank
much.
you. You have time for rebuttal.
I would just reiterate that the factors that were not considered by the guidelines were not taken into account for this sentence. She was originally given a departure sentence, and Judge Trusak did not take into account the factors when sentencing again for the probation violation.
I'm sorry, which factors?
factors that were not considered by the guidelines, such as the fact that she did testify against the co-defendants and secure convictions, that she put her life at risk, that she did complete successful probation and did her 500 hours community service and paid full restitution and was probation violation free for 2 years. Yes, she did violate, and yes, she did abscond, but the extent of the sentence, whether it be within the guidelines or not, is unreasonable and disproportionate. Thank you, judges.
Thank you. Any other questions? No. Thank you both very much. This matter is submitted. And we are now moving on to item number 19, which is docket number 361950, People versus Trevor Double.
Good morning, Your Honors.
Good morning.
It's a pleasure to be here this morning. And I am not going to argue the law
If
too
you'll
much
put your-
because I know that the panel, oh, I'm sorry, my name.
Yes, please.
May it please the court, Mary Owens on behalf of Trevor Double, the appellant.
Thank you. Sorry to interrupt, but that's one of my jobs, sitting in the middle.
I understand, and I'm sorry I forgot about that. I know Your Honors have read the briefs. I know Your Honors know, backwards and forwards, the law of ineffective assistance of counsel. So my argument today is going to be focusing on the primary category of ineffective assistance, which is trial counsel's failure to investigate the case. We agree with Judge Brickley that he did a lot of cross-examination, that he did cast a lot of doubt on the complainant's credibility. But as to the central issues in the case, his failure to investigate completely resulted in a lack of impeachment of the complaining witness. Now, the central issues we have identified as who beat her up, was she really held incommunicado? Was she really afraid of defendant, or did she love him, as she said on that video? And why was her body completely bruise-free at a certain period of time, at least?
So which of those, if I may, would an expert help with?
I don't think we asked for an expert. That's not
Okay.
one of the issues that we raised.
Then which of those, so how was counsel ineffective as to each of those factors?
Well, that's what I'm going to get to, Your Honors. And I went through the transcripts this morning of her cross-examination. I thought it would be helpful to point out specifically how we allege that his failure to investigate compromised his inability to impeach her.
And I'm sorry, thank you for reminding me. It was not an expert, but failure to investigate.
Right.
And I mean, because some of those facts that you have just gone through seems to be a he said, she said. So
What are the specifics? And I'm prepared to answer some of those, Your Honor.
excellent.
Keeping in mind that I know you've read everything and I want to keep it brief. So let's just talk about his failure to use that video, which is in the lower court record, where she's modeling the lingerie, turning around. You see her body totally bruise-free. You see, and in the still photo, you see the dog lying on the bed. So we know it's after she picked up her dog. You see the time stamp and the date stamp, April 18th. Okay, no bruises, nothing. So she said that she was abducted about April the 7th, April the 9th. So and the date stamp on the photo is 9 days. So in ordinary experience, a severe beating, you're still going to have bruises on your body 9 days later.
I thought that video was creepy. And then
It is creepy, but
the other video with her son, I thought she looked like she had a bruise around her eye.
which one? The video with
On the pier.
on the pier?
Yeah.
I did not see a bruise, but in any event, the video with the lingerie doesn't show anything. And that's, within a
It's
week or
not a
so.
high grade video and she's,
But
she's.
it's probative. It's very probative. And not only is she not saying she's not being held incommunicado, she says she loves him and wants to marry him. I'm all yours, dear. I mean, if that's not a specific area of impeachment that my client brought to the attention of his trial counsel, that's a very productive area of impeaching, and not only impeaching, but specifically contradicting her testimony.
I mean, she testified that she was afraid for her dog too. She said that he had threatened to kill her dog, to hurt her dog, and the dog is a few feet, is by him actually, closer to him than her in the video. But so he's asking her these questions right by the dog. And I don't know that that video really helps you. I think it could go either way. I
Your
thought
Honor,
it
it
was
still does-
creepy.
Your Honor, it is creepy, but it still doesn't explain why her body is so free from injury. After she said, recall the first night, she said that she had been beaten all night. And remember how she said when they went to pick up the dog, he would not allow her to go into her mother's or grandmother's house to pick up the dog because she was beaten from head to toe. Black eyes, strangle marks around her neck, that he was the one who retrieved the dog. So this happened, the video happened after the dog was retrieved. We see there's no injury at her at all. I think, contrary to what Your Honor says, I think that totally contradicts her timeline, her fear, her saying that he was beating her all the time. And that really goes to some of the central issues in the case, the ones that I enumerated. Was she really being held incommunicado? Who was it that beat her up? And how does she explain the fact that her body is so bruise free? Now, there are two more specific examples that I want to bring to the panel's attention because
I'm sorry to interrupt. There wasn't a Ginther hearing.
there was not.
Right, and there wasn't a motion for that?
Well, yes, there was. We filed a motion for, Attorney Bostic filed a motion for a new trial with a Ginther request. We supplemented that, and we also filed a motion for an evidentiary hearing. And then we filed two motions for remand in this course.
This court, okay,
Court also requesting a motion for a Ginther hearing.
okay,
Was
thank
there
you.
something in the record about a hospital? Yeah, she had a couple of hospital visits, right?
She did. She went to the hospital twice.
And she had like multiple injuries and
Yeah.
bruises and a
Someone
variety.
beat the you-know-what out of her. There's no doubt. We do not doubt that she was beaten up. But this gets to the second point of trial counsel's failure to investigate, okay? So she was, recall during that 4-week period, they encountered the police twice. And as we noted in some of our exhibits that we filed, she had told the police that someone else beat her up. But because trial counsel never obtained those police reports, he was totally unable to contradict her when she said, well, I just told him I was afraid for my dog. He wasn't able to utilize those police reports. It would have been so easy to say, isn't it true, Miss McCleary, that you told the police that someone else beat you up? She didn't even say that. And I've got the transcripts right here. I'm not going to read all of it.
Yeah, we have them too, so if you want to just
Okay.
cite to them,
I
we're
will.
happy to look it up on our own.
This is page 88 and 89 of volume 2. That's her cross-examination. That's when they told me when they take me, and after they got me out of the car, it was 4 officers. There were 4. And remember, the jury asked about this. They sent out a note about where are these 4 officers. Okay, and it goes on, the female officer asked me to remove my mask, and she gave a look at me because someone had obviously beaten her up. We don't deny that. My eyes were swollen. Did you tell them that Trevor had been abusing you? No verbal response. What did you tell them the injuries came from? Now, we know from the supplemental reports that trial counsel never got that she told them someone else beat her up. What did you tell them? The lady looked at me and she said, sweetheart, I know something is happening to you. Ma'am, I'm asking what you told the police. And I told the police, I said, I can't say anything. And the lady started begging me. The only thing I could tell her was my dog, my dog. I was so worried about your dog that he was going to kill my dog. So she totally did not mention that she had told them someone else beat her up, which was my client's position, that she had an ex-boyfriend, the father of her child, in Battle Creek, and he was the one who had beaten her up.
But she was with him both in his home and in public during this span of time that she was claiming she was kidnapped and repeatedly beaten. Multiple people, including, the incident that you're describing. And he acknowledges that as well, I thought.
Well, she was in public. Absolutely. And even the prosecutor conceded that this is not a hostage situation. She's out and around. People are seeing her. No one else testified except the police that responded to the hospital that she looked beaten or bruised or stressed or anything. But it would have been a total contradiction of her testimony for him to have impeached her with what she had told the police, bring in the police officers, which he just didn't do. So he's stuck with her answers. That's where my client is prejudiced. The jury is stuck with the answers that she gave rather than providing specific proof to show that she's lying. The other one, she says, well, he held me incommunicado. I'm not allowed to text with anyone because he's watching over me and, watching what I'm doing on the phone. And we attached the text that she had to and from her father, love you, baby. Yes, I love you too, Dad. Everything is fine. No worries. Well, there were several pages that we attached. We couldn't get all of them because, as I said, I tried to Google, I had to domesticate a subpoena for the Facebook records and not everything is available anymore. But there again, those would have been specific instances to show that she was lying. But because counsel hadn't investigated, hadn't gotten the available information, he wasn't able to show that. And the bottom line is, Your Honor, and this is the one instance of law that I will state for the record, cross-examination can be a valid strategy, to challenge someone's credibility. And there were areas on which his cross-examination I thought was reasonably effective in challenging her credibility. Like he's beating me up every single day, hundreds of times a day. He says he's going to kill me or my son or my dog. No one's going to believe that. However, he cannot legitimately or reasonably decide on a strategy until he's investigated.
So, the other thing of interest to me is how many lawyers your client had. Doesn't that also, really, if you're changing lawyers like multiple times, things can fall through the cracks, right?
Well, this was
How many lawyers did she have?
well, on trial, at the trial level,
excuse
he
me.
had Roland Lind, who was at the.
I don't need their names. I just
Okay.
want to know how
He
many
had one
lawyers.
at the prelim, and then he had the trial lawyer. And the trial lawyer had received all of the information from the lawyer who handled the preliminary exam. And my client had written down all of the things that he wanted investigated, all of the videos that he wanted subpoenaed and produced. And so there's very little, there's only a very teeny tiny little way that everything could have fallen through the cracks. It'd be different when you're on appeal. Okay, I'm the third appellate lawyer. It's easier for things to fall through the cracks with me than his first appellate attorney, than between the lawyer that handled the prelim and the one who handled the trial.
Well, the one
Presumably,
who handled the trial, though, was the first appellate lawyer, was he
no,
not?
he was not. No.
So where did Mr. Bostic withdrew
Right.
from representation?
On appeal.
On appeal.
Right.
So you're not counting Mr. Bostic as the first appellate lawyer then? If he withdrew on appeal?
No, he
maybe?
was the first appellate lawyer.
And he also played a role in the trial?
No, he did not.
Not at all.
Not at all.
How
I
many
know-
lawyers total did she have then? You are the third or
I'm
the fourth?
he had a lawyer for the prelim, a
Thank
lawyer
you.
for trial.
Okay,
Then he had Attorney Bostic, I will use his name, as the first appointed appellate lawyer. And then he had a Sato lawyer as the second appellate lawyer.
okay,
And then I'm the third one.
okay.
And Attorney Bostic did reference the video in his motion for a new trial. So it's not as though, you know, I just made it up or found it somewhere. I mean, this issue has been around ever since Attorney Bostic first represented Mr. Double, and
You're talking about, we're still talking about the video with the cops, the body cam? Are you talking
no,
about?
I'm talking about the lingerie video.
Lingerie video, okay.
Yeah, that's the one I'm talking about.
Okay.
Okay, all right.
So,
There's like three videos. There's the pier, the lingerie, and then the body camera when she was stopped with the mask on. And when she was asked, you know, they have her take her mask off and they ask what happened to her. And she said, I think she answered that like a boyfriend from Battle Creek beat her up.
yeah, why didn't he impeach her with that? Yeah, my
Well,
boyfriend.
wasn't that brought up at the trial though?
There was no body cam video that was played. That was one of our allegations
But
was
she-
that he
but
did
she-
not obtain the body cam videos.
But she admitted that she told an officer at the hospital that somebody she knew in Battle Creek assaulted her. So wouldn't it be cumulative? To bring in the body camera video? That's just the same evidence of the same issue.
Well,
It's already out there.
It's not really, Judge, because what we're talking about are the two encounters with the police, one on May 2nd and one on May 7th. Before, you know, there were two one at the strip mall, not the strip mall, yeah, strip mall, Walmarts or Targets, and one at a convenience store where the officers came up, and she told them too that she had been beaten by someone else.
I mean, I think that's the hospitals on May 2nd. And then the other one's on May 7th, right? Yeah, there we go.
I think they were
Okay.
earlier. One was April 29th then. I can't remember the dates right off the top of my head.
No, I have May 2nd, 2021 for the hospital encounter with the police, and then May 7th. Oh wait,
Well, the one that I was talking about and citing the transcript happened when they were still together, not at the hospital.
okay,
Okay.
all right,
So basically that's my argument.
okay.
I'd like to save a couple of minutes for rebuttal if I could, if there are no other questions.
Thank you.
Okay, thank you.
Thank you, counsel.
Good morning, Your Honors. Excuse me. Paige Petrosky on behalf of people of Van Buren County. I won't go through everything, but there were just a couple of points that I felt were good to touch on. Regarding the lingerie video, the time or the date and timestamp of that video, there was still substantial record evidence that she was tortured in the days afterwards. The idea that she in a pretty uncomfortable video that I mean, its opinion is subjective, but I believe the introduction of that video would potentially hurt his case, given that he was charged with first degree CSC during the commission of a felony, that being the unlawful imprisonment. And the fact that, you know, he brought her out into public, he's taking her to a strip club. There is already an issue of sexual dynamics being utilized to further harm the victim in this case. And so I think the introduction of that video would really only serve to show his interest in sexually humiliating her. As far as, and so there was a record of her being tortured afterwards. There's also record evidence that she was covering up her makeup or covering up her injuries with makeup. The video is not high quality. There's no real indication that anything within that video would actually, or I should say, there is no record support to indicate that anything within that video would actually have benefited defendant's case. And then, excuse me. That was the main.
Why wouldn't these be situations where we would remand for a hearing to ask trial counsel, did you consider introducing these videos for the purpose of impeachment? And if not, if you did consider, why did you decide not to? Or because if we got the answer, oh, I didn't even think of doing that, that places us in a kind of a different scenario than if we got an answer of, oh, I thought of doing that, but the lingerie video was so creepy, to use Judge Maldonado's term, that, we just decided that was not a good idea.
Yeah, so the trial court initially.
Or for the peer video. You know,
Yeah,
we
yeah.
looked at that and it kind of looked like maybe she did have a bruise, so we decided not to do it, right? Those would be strategic decisions as opposed to if they didn't even consider that, then we are in a different place.
Right. So the burden is when requesting an evidentiary hearing, again through hearing, the burden is on defendant to basically establish the facts that even that such hearing would be useful for the development of his claims or would be necessary. And trial counsel is presumed, you know, it is presumed that they provided effective assistance, and simply providing the videos and indicating that the videos exist, absent any other, indicating that the videos exist and that they are definitely not, you know, definitive, you know, nail in the coffin of a case kind of evidence. The presumption is that he provided reasonable assistance, and absent any indication to the contrary, there isn't the onus isn't on, or it isn't necessary to grant an evidentiary hearing if there isn't any indication that trial counsel was even ineffective to begin with.
Well, and Judge Brickley addressed the April 18th video. The complaining witness went to the hospital May 2nd and 7th, well after the April 18 video was taken. It looks as though she has done a fairly comprehensive assessment about why the items that appellant raises really would not have added from the trial court's perspective any additional information
Yeah.
either to the verdict or
To the ineffective claimant. Yes, and we very much agree with Judge Brickley's position. She makes being an appellate attorney quite easy. She does quite a bit of research on her own, and so she yes, very thoroughly addressed these videos. She, despite the confusion, you know, the issues with multiple appellate attorneys and the debatable timeliness of certain things when they were submitted, Judge accepted all of them, addressed them on the merits, and was very, yeah, we broadly agree with her position, and so. Yeah, there wasn't a sufficient basis for again through hearing being necessary.
And what about the text messages?
The text messages, again, there was record support directly establishing that defendant would direct the victim to message people to I believe I think she even called her father at one point while defendant was standing over her, still you know, using the threat of further violence against her, her son, her dog, to keep her in line and require her. And so the existence of these text messages are directly in line with the people's position at trial. It wouldn't refute anything. And she was cross-examined on the issue of whether or not she was able to communicate with her family members. I believe it was even brought out at trial that defendant brought her to go see her dad at one point. They had a face-to-face interaction. So all of this was thoroughly examined in the trial court. And the idea that introducing these text messages that only confirm what was already established would therefore require an evidentiary hearing. It just, it doesn't comport with the standards. Yeah, so I think that was. Oh, and I just wanted to state too, in regards to the discussion of the body cam video, or that there should have been further or different cross-examined about the interactions with police. There hasn't been any established, but there hasn't been anything established that these officers would have provided favorable testimony to the defendant, or would have basically. There's no record support for the idea that these the police statements would have necessarily undermined what was already established at trial. So if you have any questions, otherwise I'm all set.
I think we are all set with you.
Awesome.
Thank you very much.
Thank you so much.
Counsel. You bet. And rebuttal.
Very briefly, Your Honors. As to the police witnesses, okay, these events occurred 4 years ago, 4.5 years ago, I think, 2021. We tried, since I have been the third appellate attorney, we tried very hard to locate those officers. My client hired a private investigator, and, you know, with time, people move on, they get new jobs, they move to different locations, memories fade. So it's certainly not for lack of trying. But, and I know to a certain extent, hindsight is 2020. It would have been a lot easier to get them back in 2021 to subpoena them to testify at trial when their memory would have been fresher. But the point being, he could have at least, let's assume that these police witnesses can't be found. So there's no way at this point that we could make a factual proffer, even though that's what I have been doing for the past year and a half, is trying to find evidence to support the claims. He could have at least asked her the question from the reports, isn't it true that you told the officers that your ex-boyfriend in Battle Creek beat you up? And she said that twice in two separate police reports that we appended as our exhibits. So it's clear that he didn't even investigate that. And that would have explained her bruising and the injuries that she suffered when she was taken to the hospital. So given that, Your Honors, that's the rest of my argument.
Thank you, counsel. Any questions? No, this matter is submitted. Thank you so much. And we are moving on now to item number 20, case or docket number 367260, Simon versus Simon.
May it please the court, Attorney Fred Boncher on behalf of Lynn Simon, the plaintiff in this matter. This case is about an 80-year-old woman who lives solely on Social Security disability because of mental illness, lives in a dilapidated home infested with rodents, and so now is entering into hospice care. She is the owner of two companies in which her 49% share is valued by appraisers hired by the defendant at $4 million, an asset which the actions of her brother and the trial court have rendered useless and without any value to her whatsoever. The defendant basically just took this, her 49% interest, worth over $4 million, and the trial judge condoned those actions. The trial court allowed the defendant to be the beneficiary of his own questionable acts, which is a violation of lots of equitable cases, including the case of Noble versus McNerney, MC capital N-E-R-N-E-Y, 165 Mishap 586, 1988. Her brother who controls the company, has a home in Ada, Michigan, a home in Florida, and a cottage up north. He, one, is taking company funds to hire his children as real estate consultants, almost $300,000, without virtually any consideration, and we at the court said that was just a quote modest amount. Two, he unilaterally decided to pay himself rent for storing junk he keeps for the sake of memories. He testified that he had tried to sell these or tried to rent these homes or these two buildings for 2 years, and he couldn't do it, so he decided to start charging the company for the rental. Well, if he would have been able to rent them, he obviously would have had taken all that junk out of there and had it put in a dumpster and gotten rid of, which shows in itself that there was junk and not, something of any value to be kept.
Well, the judge looked at that, and I think the issue there was that they'd gotten free rent for some period of time. And then secondly, the judge was like, well, I'm not supposed to question business decisions. So do you disagree with that? You think the judge should?
Yes, and why do we even have minority oppression statutes? And if, whatever you decide to do can be considered a business.
I'm sorry, I don't think I was very articulate. He said, well, it's not a great business decision, but it's not like, I think what the record is like, it's not a great business decision, but it's not unreasonable either. Like,
again, it's something that she never knew about. Money was going out. She knew nothing about it. And furthermore, the business judgment rule was never raised as an affirmative defense. And yet that's a main thing that the judge built his decision on. Number 4, he was illegally paying his attorney fees with company funds, something even his own expert attorney said was wrong, in violation of MCL 450.1564A. Number 4, tried to buy out his sister's 49% share of the companies with a lowball offer at a small fraction of the value. In the Schmetke case we cited in our brief, that's a good example of how that's oppression. When even defendant's own CPA, Mr. Payton, said that once he found out, what the offer was and how much money the company was worth, said it wasn't fair. Lynn herself had no idea of the value of the company. because he never provided her with information necessary to know what it was worth. She got tax returns, but even their own CPA said that wouldn't tell her what the company was worth. She didn't get financial statements in violation of law. Number
The
5,
bylaws do allow him to pay his attorney. I thought the bylaws allowed him to pay his attorney fees, but she was saying she just didn't know that the bylaws allowed you.
no, the bylaws allow indemnification, but that indemnification is subject to the requirements of the statute that shows it has to be voted upon by uninterested directors or by opinion of a jury of council. None of those requirements of 450.1564A were met. You just can't willy-nilly say, I'm going to indemnify this stuff and ignore the statute that says under what circumstances I can do that. Yeah, you can put it in the bylaws, but it's still subject to the statute.
You don't think the statute says that if you put it in the bylaws, you're complying with the statute?
No, because otherwise there'd be no reason why the statute would have all those requirements. If you would just say you can do whatever you want if you put it in the bylaws, that would just make that statute of no effect whatsoever. But it's got to be able to do it. First of all, you have to put it in the bylaws to have it happen at all. And second of all, it has to be still subject to the statute. See, he paid his children secretly without adequate consideration. They were still in high school. One was still in high school, paying as real estate consultants. They never took any real estate classes. One was a nurse, one was studying law, and he became an SEC compliance consultant. He took advantage of Lynn's disability, a lack of funds, a lack of knowledge. Number 7, he refused to get appraisals despite the language of the stockholder agreements and operating agreements. 8, he refused to allow Lynn any control or involvement in management despite the language of the stockholder and operating agreements. 9, he named his son as a director and paid him director fees over Lynn's objections. In fact, on the August 1st, 1919 board of directors meetings, one of the few that he actually called. She made a number of motions. He just simply voted her on everything. He paid her director fees and other expenses, not by taking corporate funds or LLC's funds, but rather just simply reducing on the books of the company what the company was owed to her. So he even had her the temerity to buy her a birthday present using her own funds. So he wasn't giving her anything. He was just reducing what the company books showed was owed to her. Number 11, he's even stopped paying her now anything, even out of the accounts payable owed to her per the company books or any director's fees. Number 12, he failed to pay dividends despite increasing profits, a shareholder agreement that says 40% of profits are to be paid each year in dividends, as Mr. Adamy pointed out, our expert, and despite the company having $1.3 million in cash. Number 13, he made additional expense payments to its children out of company funds. Mr. Adamy said that was about $50,000. Number 14, he prevented Lynn from monetizing, to use the words of Judge Yates, the prior trial judge, her 49% share. 15, subjecting the company and Lynn to possible IRS liability. 16, coming to Lynn's house late at night to sign documents without explaining them or even knowing her mental disability. And when questioned about this, Sandy said, "Oh, you don't need to know. Cindy knows." That was twice she said that. That's what he said. Number 17, forging her name to documents. Number 18, making false representations to the bank under her name about how they had a meeting when they never had such a meeting, and voting a resolution which they never voted on. Number 19, forcing her to practically beg for necessary payments of expenses, even though those expenses were coming out of money owed to her in the first place.
It sounds like with due respect, I appreciate these various points. I assume that they were raised before Judge Benson following the multi-day trial.
Yes?
And we sit here as an error correcting court. So what did the trial court, having considered these facts that were placed before him over a multi-day trial, how did he err with those facts?
Because he is required to make an equitable decision under the statute. And this was not equitable. This is not equitable at all. They're decided by the court in oppression cases as court and equity. Is it equitable the defendant can engage in all those acts of oppression with impunity? Is it equitable that Lynn's $4 million asset is now virtually valueless, to use a phrase from the Schmidtke case, and it's now entirely valueless? She can get nothing out of it. He won't give her anything out of it. Is it equitable that Lynn cannot at all monetize, to use Judge Yates's words, her $4 million investment, but was required to live in abject poverty? Is it equitable that Sandy's children gets all the benefits of the value of the companies? Something that said, well, that's what I'm doing. I'm trying to build up value for my own children and taking care of my own children. So they totally ignoring the 49% share of the company and his fiduciary duties to that 49% shareholder. That was not, none of these actions were equitable at all. And also he improperly interpreted misapplied relevant statutes, including the one dealing with indemnification and the oppression statutes at all. I think she was oppressed, clearly I was oppressed as a stockholder. It wasn't equitable at all. And equitable cases or equitable principles that he is required to follow according to the statute in making the decision, including equitable cases that say, for example, defendant cannot take advantage of his own misconduct. A litigant should not be the beneficiary of his own questionable acts. That is the case of Noble versus McNerney, which I cited to you a minute ago. Number two, a court of equity is not to be made an instrument of a wrong and will not any enforcement of an illegal or fraudulent agreement or transaction. Well, that's what the court did in this case. It's cardinal rule of equity that one who seeks equity must do equity, and equity will not aid a party in doing which is not equitable. Kirkendall v. Hechinger, Hechinger, 403 Miss 371, 1978. Also, Attorney General v. Thomas Sullivan Company, 146 Mishap 55, 1985. Likewise, a court of equity is not to be made an instrument of a wrong. Well, that's what the judge did in this case. That's wrong versus Cornwell, Miller versus Cornwell, 71 Miss 270, 1888, going way, way back. Equity demands clean hands. That's something we learned all in law school. That's not the case in this situation. In fact, the doctrine of clean hands can be applied by a court of equity on its own motion when an unconscionable character of a transaction between two parties is disclosed. That's Chapman v. Chapman, 31 Mishap 576, 1971. Equity has the power to create new contracts between the parties or in the absence of fraud, accident, or misguidance to supply admissions and contracts deliberately made. Nash versus Bouchard, B-O-U-C-H-A-R-D, 87 Mish 85, 1881. In this case, we are seeking a buyout of her assets. That's the only way she's ever going to get value out of owning 49% of these companies. And that was what was kind of interesting, that the agreements themselves, both of them provide for a buyout if he wants to buy her out by just taking the book value of the company. Mr. Adamy concluded that was over $4 million. That's, I guess, what's good for the goose is good for the gander. That allows him to be able to buy her out. It doesn't, he's not required to buy her out, but it seems if the court were acting in equity, and equity means fairness, and fairness in this particular case between these two stockholders, he would have agreed that that's a good, fair way to resolve this case.
Right, that would be a remedy.
Right, and that's what
First, we got to get to, first you got to get to whether there was oppression. I mean, would you say would it be fair to say that your position here is not necessarily that the trial court made errors in terms of the findings of fact, but that putting all the facts together, you don't believe that the conclusions of law were correct about whether this counts as oppression under the statute?
Generally, yes, but even as conclusions of fact, like saying $300,000 is a modest sum, that's not, I don't know. Sure, it seems like a lot of money to me. I would think most people think $300,000 given to his kids is a modest sum. I think many of his, and he ignored things that, like, their own CPA said it wasn't fair for the buyout. He just glossed over that. He ignored many things. He ignored the statute requiring that attorney's fees have to have a vote of unregistered shareholders. That's a question of law, but it's also a question of fact. But what's really clear is from a matter of law and application of equitable principles, which is he's required to do in construing and ruling on those two statutes about oppression. He failed miserably. And he said, talked about totality of the circumstances. Well, I still have a few more points that I could bring up about totality of circumstances where, she has got this investment that she got from her father. So she's never going to get anything out of it, and he can do whatever he darn well pleases, and the judge condoned that. That's not equitable at all. I'd like to reserve some time if any more questions.
I think if we stop there, you'll have a couple minutes for rebuttal.
Thank you, ma'am.
Thank you.
Good morning, Your Honors. May it please the court. Jim Brynsma on behalf of the appellee, Sandy Simon. This court should affirm the decision below, which was made after a trial. And at that trial, the court found that the plaintiff appellant here failed to establish the claims that she was asserting. That trial involved the testimony, extensive testimony of the parties themselves, involved the testimony of all the professionals that had serviced these businesses for decades. Lawyers, the outside accountants, they went in detail through the accounting records, journal entries, matching up checks to ledgers. And of course, this court gives great deference to the trial court's ability to hear that testimony, to evaluate that testimony, to evaluate the credibility of the witnesses, to weigh the testimony and make judgments and draw inferences from that. And so unless there is clear error, which means there has to be no evidence or a firm and definite conviction that a mistake was made, your role here is to affirm the findings and the conclusions of the trial court, and that's what you should do. Now, the key claims that were at issue below really are the minority oppression claims. And the Franks Court lays out the elements of a minority oppression claim, whether it's under the Limited Liability Company Act or the Business Corporation Act. They're both implicated here because we have both types of entities, and they're effectively interchangeable. I'm not going to go through all the elements, but there's three of them that really were at issue, and I think that are what I would just emphasize today. One is, did Mr. Simon engage in acts that were willfully unfair and oppressive? Did those actions, if they occurred, substantially interfere with Ms. Simon's interest as a shareholder? And most importantly, did Mr. Simon have the requisite intent to interfere with her interest as a shareholder? And I'm going to take those in reverse order because the third one, which is the intent, is a showstopper and really wipes out all the other allegations here about minority oppression. The testimony at trial was clear. When Mr. Simon took over this business, he was 60 years old. This was a second or a retirement career, if you will, for him. And what was the state of the company? It was a mess. His father was in failing health. They had just lost their prized possession, which was the Stadium Arena in Grand Rapids, which was a performing arts center, a hockey venue, because it had been overrun by Progress. We had a new arena here in town. And so there was an insolvency and they couldn't make the debt payments and lost that. The company is awash in debt, but they also, after the death of his father, owe the IRS $136,000. And to avoid that liability with the IRS, they enter into an agreement under which they must keep the real estate in the family for 10 years and not convey it, or else they owe that liability to the IRS. And so how are they going to keep the property in the family when they're awash in debt and they've just lost their crown jewel? Through hard work. That's how. And it was Mr. Simon's hard work.
Didn't he also loan a lot of money to the company?
What's that?
Didn't he also loan money to the company?
Well, absolutely. I mean, so one of the things he did was when they testimony was when they had to do the refrigeration for the hockey team, they needed new refrigeration equipment. He made loans so that that could be done. And so this was a situation in which the intent that was inferred and the intent that was testified to was that he was trying to save the company for the family, for the benefit of the family. And that's in fact exactly what happened. And so at the time that he took over, the appellant was holding an asset that was effectively worthless and an asset that she was in no position to do anything with because she herself was not capable of providing the services necessary. And so for a modest salary, Mr. Simon took over, he built the company back up, he paid off the debts.
Well, and she took a salary as well.
Exactly.
Without providing any benefit.
Right, and he did not cut her out of the management of the company. He allowed her to be a director, even though that is not a requirement of a shareholder. That is not one of your rights as a shareholder to participate in governance of the company, but she did participate. And every year she was provided with consent resolutions that were prepared by outside counsel. She executed those consent resolutions. And so for her to say that I had no role or involvement in the company, it's simply belied by the evidence. But the standard here is not whether there was evidence. The standard here is whether there was an error by the trial court when reviewing that evidence and the evidence at trial. And clearly, they haven't come within a country mile of establishing that the trial court made some sort of error given the testimony below. And again, it was not testimony that was merely the plaintiff or the defendant themselves. It was the third-party professionals who had no dog in the fight, who worked for the company for decades.
Again, to Judge Karobkin's point, I think this came at, following 4 days of trial where we, obviously the trial court was charged with assessing credibility, which clearly we have no role in doing that. We have to be deferential.
Exactly. And so Mr. Simon was he was the first witness. He was on the witness stand for 7 hours the first day, and he was on the witness stand for an hour the second day. So if there was any question about him being subject to cross-examination, what he did, why he did it, what his motivations were, that was all fleshed out exhaustively in the trial court.
Do you want to address the attorney fee issue? Because that is an issue of law, it seems to me, rather than one where we would defer to credibility.
Sure. And so here there's indemnification provisions both in the operating agreement for the limited liability company and in the bylaws for the company. Business Corporation Act allows for the shareholders of a company to modify the statute or the statutory scheme in the bylaws, which they did here. This was a specific amendment that was adopted by the shareholders that provided for mandatory indemnification without any of the bells and whistles in the statute. And the same thing is true in the operating agreement. The operating agreement provides for mandatory indemnification, and it doesn't require all these sort of independent committees or anything else with a family business that's closely held. Here, the evidence was that Ms. Simon had signed off on consent resolutions that specifically authorized healthcare reimbursements, the payment of salary to Cindy Simon, payment of bonuses to Mr. Simon, and yet those were allegations in the complaint. So Mr. Simon was sued for things that the directors of the company had authorized him to do. And that is a blueprint for when you get indemnification, because that's what both provisions say in the bylaws and in the operating agreement. If you perform services on behalf of the entities and you get sued for doing those things, then you're entitled to mandatory indemnification. And that's precisely what happened here. And so there's no question that he was entitled to be indemnified, and he was indemnified. And the court correctly determined that under the terms of the operating agreement and the bylaws, he was entitled to that. And I should say too, it really doesn't matter which one you go under, because you only have one lawsuit. You have one deposition, you have one trial. And so if he's entitled to indemnification under the operating agreement, he's entitled to it for the whole case, even if you say, well, we didn't quite make it under some other theory. So
does it matter if, I thought counsel said that the company paid the lawyers directly versus indemnification. If I heard that correctly, does that?
No, that's the company did pay the lawyers directly. There's mandatory indemnification. It does not mandate advancement of fees, but it would mandate reimbursement in any event. So there's no injury related to the payment of those fees. And so even if you say, well, the sequence was a little off, she has no oppression or injury because of it. It's just timing. There are other points I could make, but I think the key here is that we have a trial. We had a court that listened to the testimony, considered the testimony, made his determination, and there has been no basis shown why there's any error in that determination, just simply second guessing or I don't agree with what he did. And that's not the standard. So unless you have questions for me, those are the points I wanted to make.
Thank you very much,
you.
counsel. And rebuttal.
Well, the elements of oppression, certainly willful acts of oppression are present in this case. Interfering with her interest as a stockholder basically took away her total interest as a stockholder. Requisite intent, he came right out and admitted, yeah, that's what I did and that's what I intended to do. I was trying to build up the company for the benefit of my children, not for the benefit of his fellow shareholder to whom he owns fiduciary duties. We don't disagree that he helped the company. He did a good job over all these years. It's just like, whoever, when they first started Microsoft, it wasn't worth a whole lot of money. But after a while, one of the guys really built it up. Does that mean he doesn't have to pay his other fellow shareholder his share of it? No, that's totally irrelevant. And the judge seemed to focus on that. That has nothing to do with the acts of oppression and where we are today and where we were at the time of the trial. He had also the loans to the corporation. The judge, finds the fact he ignored a lot of the evidence. He kind of picked and chooses. So here's the stuff that support my findings, but the loans, it was very clear that loans that carried in the books owed to him were made to his father personally. The judge says, well, I don't recall exactly what that transcript said. I'll go back and check it. Didn't go back and check it, but we pointed out in our brief what it actually said, and it was a loan to his father. As far as like the Jan Iwina, the bookkeeper, said she admitted that there were no financial statements sent. She admitted tax returns would not show all the oppression. She admitted that the kids didn't do much work. She admitted that there was there's nothing on the books of the loan indicating in the books of the loan except one, that $196,000 that he admitted was to his father. She admitted that there's no dividends, even though they have $1.3 million in cash. That in itself is under the case law showing some oppression.
I'm going to interject because if you can tailor your comments specifically to counsel's argument,
Okay.
That's really the point of rebuttal, and we've got about 2 minutes.
The court asked about deference to the judge. Well, deference to the judge on the points of fact, he ignored that, and that deference shouldn't be granted when he ignored things like Mr. Payton himself saying the lowball offer wasn't fair. He ignored facts, and it should not be deferred to when Mr. Brackman admitted bylaws amendments were passed without any agreement. The court ignored the fact that there should be no deference when the judge didn't say anything about the fact that what she did receive was not money coming from the company, but was just taken out from her. In the court, so there's all kinds of factual things he just ignored, like no loan approvals. He didn't mention that. He didn't mention anything about failure to, as required by the Business Corporation Act, to hold meetings and call meetings, which he never did at all. And he ignored seemed to feel that there was ratification, and that was just brought up by defense counsel. But you have to know what's going on to be able to ratify an act, and just say, we moved to ratify everything from a year before. If you have no knowledge of what was being done, that's not a ratification as a matter of law.
Okay, you are at your 2-minute mark, counsel. What would you like to say in summary?
One, the facts of the findings of facts did not include all the facts that were put into evidence. Number two, the oppression has to be based upon equitable principles. There's nothing, and God's green earth makes this decision equitable at all. He's basically, the defendant's basically just taking her share and doing with it whatever he wants to benefit his kids. And that's it. Thank
All
you.
right. Thank you both very much. Appreciate your time. This matter is submitted. I have a question from my colleague. All right, we're going to take a quick break before we hit the last two matters on the 10 o'clock call. We'll be back.
Thing I said?
No, it's there. We vacated. Yeah. We certainly can take the two matters that were at the top of the docket right now. If we have, I'm going to call them together as they involve the same parties. Item number 15, which is docket 368, 625, and 16, which is docket 368, 626, People versus Jack Smothers. And we should have Mr. Waldo, excuse me, Mr. DeGraw. Thank you. By Zoom.
Good morning, Your Honors. I'm just trying to, there we go. Good morning, Your Honors. Brett DeGroff from the State Appellate Defender Office. Thank you so much for indulging me and allowing me to appear on Zoom. Drove the wrong direction today, so I would have rather been with you in Grand Rapids, but I appreciate the court's indulgence.
Could happen to anybody.
You can proceed as you are the only one endorsed for argument.
Thank you, Your Honors. I would like to focus on issues 1A and B and also issue 4. Happy to, or excuse me, yeah, also issue 4. Happy to answer any questions the court has, though. As to
And I've called both cases, so when you say the issues, you're including both cases, correct? You've got 2 appeals.
yes, Your Honor. So I'm speaking to the stalking and terrorism charge.
Okay,
Yep.
we'll deal with that first then.
Okay, so as to the so our issues 1A and B, there are some elements to this offense include there must be a course of conduct, and repeated or continuing harassment. There are neither of those things and no evidence presented to support either of those elements. In terms of a course of conduct, this court can look to Polberski, where the court discussed that phrase in this statute and required for it to be a course of conduct that the acts must be joined without intervening space, without cessation, interruption, unbroken. Excuse me, that if it's in this case, these acts were all at the same time. They were right about 6:48 a.m. They were just phone calls that went all to city government. So there's no disruption in time or space, which would lead to any sort of course of conduct. In terms of there being repeated or continuing harassment, to know if there's 3 calls here, and to know if that is repeated harassment, you have to know what one unit of harassment is. And you might think that a phone call could be a unit, and in some contexts it might. You might think that if we think about an analogous situation, if you think about someone shouting at another person on the street, you might think that one incident of someone shouting at another person could count as a unit of harassment, and it might. But if someone shouts at another person twice in quick succession, that's not 2 units of harassment. That's just one. That's just one incident. And we don't have to talk off the cuff, and I don't have to appeal to your intuition because my argument is grounded in the text of the statute. If you look at 75411HE, it says that for something to be harassment, it needs to be something which would cause a reasonable person to feel, D is harassment, and that's conduct directed towards a victim that would cause a reasonable person to suffer emotional distress, and that actually does cause a person to suffer emotional distress. So to have more than one unit of harassment, you have to have two separate times that the complainant was caused emotional distress. And there just isn't that here because the complainant received reports of all the phone calls at one time.
Yeah, but the fact that there were multiple phone calls is, in my mind, part of what made the threat credible. Like, it was a much more concerning threat that it went to multiple people in multiple spaces, and was repeated, that it just wasn't one. So that's not legitimate in terms of, I mean, it's just, I think what you're saying is, that's a valid interpretation of the statute, but I think my interpretation is also valid. Why don't you explain your position a little bit more?
For there to be, the statute requires repeated harassment, more than one instance of harassment. To know if there were more than one instance of harassment, you have to be able to define what one unit of harassment is. And the statute does that for us. There's two requirements. That the conduct is something that would cause an individual to suffer emotional distress, and that it did cause someone to suffer emotional distress. So to have repeated harassment, you have to have at least two times where the complainant was caused emotional distress. That didn't happen in this case.
So Deputy Randall affirmed that he felt frightened, terrorized, and intimidated. He changed his routine to minimize the opportunity for the defendant or somebody else to shoot him from behind. Because he used to do something. Oh, he used to write his reports, I think, in his vehicle. And then didn't he testify that this incident led him to retire?
Your Honor, I'm not disputing about whether or not the complainant was caused emotional distress.
Okay.
I'm saying to have repeated harassment, he must have been caused emotional distress at two different times. Because to have repeated harassment, you have to have two units of harassment, right? Otherwise, it's just one harassment. It's not repeated harassment. The complainant received the reports of the phone calls all at one time. He was only caused distress once. So there's no repeated harassment. So that's not stalking.
I didn't really see much case law on that point. Do you have any authority? I'm skimming the brief that was written on behalf of your client. But it's somewhat a novel argument, this unit of harassment, which I have never heard it referred to like that.
I mean, I'm just reading the statute and it says repeated harassment. And to have repeated harassment, you have to have a more than one.
I understand. I think it's just an interesting term to use, unit of harassment. But again, I'm scanning through the brief that was filed. There doesn't appear to be any authority interpreting that kind of unit concept, or whether communication to third parties can also formulate the basis of unconsented contact with that individual, right? Because some of these communications go to third parties rather than him. Do you have any law that you can point us to other than the plain language of the statute that is a favorable interpretation to the position that you are advocating?
So in terms of the brief talked a little bit more about my phraseology is a little bit different than the attorney who wrote the brief, and I apologize for that. We're making the same argument. There was a little bit more in terms of course of conduct. The course of conduct and repeated harassment are very similar arguments. And I think logically, they sort of turn on the same thing. And
Right, but I'm asking, is there any case law that we should be specifically looking to in the interpretation of the stalking statute that bolsters the position that you are making? Because I think it's more a common sense argument rather than something tethered to a pronouncement in a specific case. But that's what I'm asking about. Can you point me?
If I might, Your Honor, my answers are yes, no, and I disagree with you slightly. So if I could do all three of them. In
Go
terms
for it.
of, I've sort of made two arguments at the beginning here about the phrase course of conduct as it appears in the statute. And my answer as to authority, the answer is yes, that's Poberski, which is directly on point. The second argument I've been making is about the phrase repeated or continuing harassment. My answer is I don't have a case that interprets that language. I'm relying on the plain language of the statute. And of course, as your honors know, questions of statutory interpretation, you do de novo.
So
The example that you gave was like this rapid fire, heckling of somebody. But in this case, your call to 911 is at 6:48. Then the phone call to the city manager's office is sometime before 8 a.m. And then the third phone call is 8:05 a.m. So you have at least an hour gap in there between the first one and the last one. That is not analogous to the rapid fire heckling, in my view. I mean, I think a jury could reasonably find that those were separate acts. That's not crazy to say that those are separate acts of harassment with an hour difference.
I think that sort of intuition that Your Honor is discussing might go towards course of conduct, but I don't think that would go towards the phrase repeated or continuing harassment, because in some sense, we rely on intuition a bit and Poberski and the guidance that it gives us in interpreting course of conduct. But repeated and continuing harassment, the statute is extremely clear. To be harassment, it has to do two things. The conduct has to be something that would cause a reasonable person distress and that did cause the complainant distress. There was only one time when this complainant was caused distress, and it's when he received the reports of the phone calls.
Can I break it down a little bit, because it's a little frustrating with the statute, because we've got subsection 1D, which defines harassment, and then we've got subsection 1E, which defines stalking. Of course, to get to stalking, you have to first have harassment. And harassment means conduct directed toward a victim that includes, but is not limited to, repeated or continuing unconsented conduct, which would cause a reasonable individual to suffer emotional distress, and that actually causes that. So that's harassment. And then to convict someone of stalking, you need to have a willful course of conduct involving, and then it again says repeated or continuing harassment that would cause a reasonable person to feel blah, 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 harassed, and that actually causes the victim to feel harassed. And so I understand your point here is that even if there were more than two separate and non-continuous phone calls, the victim in this case learned of all of the phone calls at one time, and therefore only felt emotional distress once. Is that right? Okay.
Yes, Your
But-
Honor.
But why, I guess I'm hearing what you're saying, and I'm not quite linking it up with the statutory text, because it does seem that harassment itself can be repeated or continuing, and stalking can be repeated or continuing. But I'm not sure I'm linking that up to you have to feel the emotional distress repeatedly.
So E, which defines stalking, requires repeated or continuing harassment,
Yep,
where harassment is defined by D.
yep.
So E requires repeated and no one's argued continuing, so I think we can just say repeated. Because the continuing, I mean, doesn't.
Three phone calls, right.
Right. So, and not over days or weeks or months when you might typically talk about stalking happening. We're talking about an hour. So I think we're really talking about repeated, and I don't think the prosecution's argued otherwise. So to have stalking, E requires repeated harassment. All right. So we need more than one instance of harassment to have stalking. Otherwise, it's not repeated. How do we know when we have an instance of harassment? Well, we look to D. And among other things, well, not really among other things, there's really only two requirements. And D has sort of a list of one example in the middle of this, which I think we can, it's a little bit oddly written. But so if you skip over the example, which is repeated or continuing unconsented contact, excuse me. D defines harassment as conduct directed towards a victim. Okay, that doesn't tell us much of anything. That's just people interacting that would cause someone to suffer emotional stress and did cause. So for harassment to happen, the last part, someone had to be caused emotional distress. If that happens, and it was something the reasonable person be caused distress by, okay, you have harassment. Okay, so when the officer received the phone reports about the phone calls, assuming that's something that would cause someone emotional distress and that it did cause him emotional distress, that would be harassment one time. When he received the phone calls, where's the next one? There is no next
So
one.
your argument is if he received a report about the first two phone calls and felt, harassed or felt distress, and then an hour later or whatever time later, he got the report of the last phone call, that would satisfy the statute.
That might.
Okay.
Yeah, I mean, we're talking about I guess we're talking about what the word that does in either D or E. I mean, there were, if we take that there were multiple phone calls and they were separate and non-continuous, then you have all three of those things happen. I don't know that it's clear from the statute that, and if those three things together cause emotional distress, I guess I'm not sure that you have from the statute that each thing has to cause emotional distress in separate and non-continuous instances. But I get the argument.
And I guess the only, and I can move on.
It's a really interesting question. I'll put it that way.
Okay, and I guess the only thing I would leave your honors with, the question that I would ask you to grapple with is if there is repeated harassment here, and if harassment requires the victim to suffer emotional distress. And I don't think that's debatable. I think D is very clear on that for harassment to occur, a complainant must suffer emotional distress.
Yes.
If there's repeated harassment, when was the second time? There's no allegation that there ever was a second time. And that's the question I'd ask your honors to grapple with as you work on this case. And in terms of issue 4, there are not a lot of bright line rules when it comes to what prosecutors can say. We oftentimes, the comments, prosecutors' comments are looked at in context in the whole trial. And I'm not a trial attorney, but I've done evidentiary hearings. I understand people are there for a long time. A lot of words come out of people's mouths, and, and putting them all in context. I understand all of those things. But what that means is there ends up not being a lot of bright line rules for prosecutors to follow. This is a bright line rule. Prosecutors can't ask the jurors to put themselves in the complainant's shoes. They just can't do it. It's not a hard rule to follow. It's an easy rule to follow. The prosecution has not argued that that's not the rule. They've argued that that's not what the prosecutor said, but it's quoted in both of our briefs. And I mean, it's pretty clear. She said, you put yourself in the shoes right there. You're all reasonable people, and that's why you're on a jury. Think you'd have some emotional distress, multiple calls, yelling, threatening your life? I would hope so. That's not close. That's not something that prosecutors can do. And there's only one way to stop them from doing it, and that is to vacate convictions when they do this sorts of thing.
Do you
Because
think comment applies to both the egg stalking and the terrorism charge then? Because obviously, if we're only focused on the egg stalking, we've still got the terrorism charge.
yes, and I apologize if after we discuss issue 4, if I could go back, because I didn't discuss 1B. And I would like to do that as also. So I'll finish with issue 4, but I think that only would apply to the stalking charge. Yes.
Okay,
Well,
thank you.
what's our standard of review for that issue? Is it preserved?
I apologize, Your Honor. I can check my brief. Again, I didn't write this brief. The case was transferred to me
I don't
recently.
believe there was an objection at the time.
Yeah.
So if it's unpreserved, I mean, it's a question of law, and then if it's unpreserved, it's going to be a constitutional question which should be reviewed for plain error.
Okay, thank you.
Okay, so back to issue 1B, and that's the terrorism charge. So to satisfy this element, or to this offense, one of the elements that needs to be satisfied is 750 543BA3, which deals with coercion of public officials or the government. And the prosecution hasn't, their response to our argument is that Mr. Smothers. So our argument is that he was just saying, if the police harass me, I will defend myself. And that is not, and that's not in violation of A3. The prosecution hasn't actually argued that we're wrong about that. They haven't said that, no, he could call and he was not allowed to call and say, if they harass me, I will defend myself. They haven't argued that. They said that that's not what he said when he called. And their argument is only about a page, covering 2 pages of their, spilling from one page onto the next of their brief. In one paragraph, they summarize our argument. In the next, they have a lot of quotes to the record. Every quote in their response to us has Mr. Smothers saying, if I'm harassed, I'll defend myself. If you mess with me, if this, if that.
But he's talking about in context when I was reading that. And maybe, maybe I'm getting something wrong here, but I thought he was talking about, if you harass me, he meant if you make me leave the park. which he's not supposed to be sleeping in the park. And so the cop was asking him to leave or requiring him to leave, or I'm not exactly sure, but somehow ejecting him from the park. And so basically, if you're doing your job as a government official, then I'm going to kill you. That's the
I don't think that's a fair reading of
Okay.
Mr. Smothers' comments, Your Honor, because Mr. Smothers isn't talking about past events when to the extent that he mentions past events, that's not a threat. To the extent he's talking about future events, what he's saying is, if you harass me. Now, Mr. Smothers certainly doesn't say, now, people have reasonable difference of opinion. There's a lot of context here. It's a high emotion situation. That's true. We don't know. We don't have a record about every time Mr. Smothers interacted with the police. There's a record about some of them. I think you're right that sometimes Mr. Smothers was in the park when he wasn't supposed to, and police asked him to leave, and maybe that was okay, and maybe it wasn't. But what Mr. Smothers is saying on the phone is if you harass me in the future. And so when Your Honor is asking about specific facts, Mr. Smothers is referencing future hypothetical instances. So there's no specific facts to tie what he's saying to, because he's talking about if you do something to me in the future. And certainly Mr. Smothers didn't say, if you do your job lawfully, I will defend myself. He said, if you harass me, I will defend myself.
Well, yeah, but okay, so we have the 911 call. And if I'm remembering the 911 call, he describes being moved out of the park, doesn't he?
Yes. I believe you're right.
Okay. So I'm still unclear as to what I'm getting wrong.
Your Honor, Mr. Smothers isn't saying, if Mr. Smothers had called and said, I'm going to take revenge for things you did in the past, that would be a totally different thing, right? That would be a threat, because he would have been saying, I'm going to do something because of what you did in the past. That would be a threat. But that's not what he's saying. He's saying, if you harass me in the future, I will defend myself.
So I guess going back to the text of A543B, A3, I think that's what we're talking about here. It says that the act has to be intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. So I mean, regardless of whether it's removal from the park or harassment, isn't the threat to kill something where the jury can say, well, that was intended to influence or affect the conduct of government through intimidation?
I don't think that saying I will defend myself if you harass me is intimidation.
Well, but he said, I mean, you said defend myself, but doesn't he also say I'm going to shoot him in the head?
He does. He uses more extreme language. You're absolutely right.
So, I mean, I think that's what the jury probably was fixated on more than defend myself. And I guess the question is whether they were allowed to do that. And it seems like, I mean, putting aside why this statute was enacted in the first place, which may be somewhat far removed from this particular situation, if you just look at the text, it does seem like threatening to kill somebody who's a police officer who's engaging with the public could be taken to be intended to influence or affect the conduct of the government.
And Your Honor, the only response I would have to your point is what you described was certainly if you're to threaten police officers for engaging in their work lawfully, that sounds like A3 to me. If you say, if you harass me, I will defend myself. And I acknowledge Mr. Smothers used different and more colorful language that I don't necessarily want to repeat, but I acknowledge your point. That is not the same as saying, if police officers do their jobs lawfully, then I will take some action. Saying that and saying if police officers harass me, I will defend myself are different things.
But
And I
he
don't
defined,
think,
but he defined it as past action of removing him from the park. He
he
defined
talked
it
about,
himself.
I apologize for the lag, Your Honor. I didn't mean to talk over you.
Okay,
Um,
it's an interesting case.
And so, Your Honor, again, just, you're right that he does reference past actions, but when he talks about his future actions, every one of them is couched in terms of if they harass me. And the prosecutor's brief takes that's true with all their quotes except one, which they've taken out of context. They take out of context and just quote him saying, "It's over, he's done." And that is not that's not the entire quote. The entire quote is, "When I sit in the park and he harasses me again, it's over, he's done." So all of these things are the same time. Are the same thing. Mr. Smothers is saying over and over that he will defend himself if the police harass him.
Do you remember whether the sentence for the terrorist threats was longer than the sentence for aggravated?
At top of my head, I don't, Your Honor. I'm sorry.
Okay.
I think, do we have any other questions
Not on
on
this one.
this one? Can we transition, counsel, to the next case, item 16 on the docket?
Sure. I don't have a separate presentation for that case, Your Honor.
Okay,
Okay, you rest on your brief then?
Yes.
All right. Does anyone have questions for counsel? Okay, then what we will do is submit both of those matters and we will get you an opinion as soon as we are able. Thanks for zooming in today.
Thank you and again, thank you. I'm so sorry for the confusion.
no worries.
problem.
Could have happened to anybody.
Have a good day. Thank
You
you.
too.
And now we're on to the 11 o'clock docket. So let's take item number, I believe it's 21. And that is Bethany Hill versus Joseph Hill, docket number 374724.
Good morning, Your Honors.
Good morning still.
Finishing up my notes on that one.
Do we have, I'm looking to see, I see that opposing counsel is endorsed. Have we heard from anybody? Okay, all right. Well, we're an hour past, so I'm inclined to just forge ahead. You can proceed, counsel, beginning with your appearance.
I'm Jennifer Alberts and I represent the appellant, Mr. Hill. And I'll just keep this brief, Your Honors. I think that this case is pretty clear cut. In Quint versus Quint, this court held in a published case that it's plain error to not apply just one of the best interest factors in this case, even when it wasn't preserved. And in this case, the trial court didn't follow any of the standards of the Child Custody Act. There's the proper cause and change of circumstances standard. There's the determination of the burden of proof through the established custodial environment. And
I was curious about that, quite honestly. And I say that because this notion of the ECE, which is the established custodial environment, and that determination driving the burden of proof. Here we have joint legal custody. That's the issue, which is joint. I mean, isn't it obvious what the ECE is here?
I mean, I would say that it was a joint ECE, but that's still, I would say that it's still the trial court's job to acknowledge that, just so that we know that the trial court is applying the preponderance of the evidence burden of proof. But
Isn't the bigger problem that we don't have a recitation or a rundown of all the best interest factors with specific findings?
I do think that's the biggest problem.
Yeah, because again, I was racking my brains on this one, having done family law before this existence, as a trial court judge. And I mean, I get the ECE determination is critical. And when you're talking about physical custody, that's different, right? Because it's who does the child look to? I mean, that's the definition, right? Who does the child look to for that established custodial environment? Well, kids don't look to their parents for legal custody. It is what it is. So whether this court acknowledge that, I mean, can't we acknowledge it and send it back and say, pretty please do a best interest analysis? I mean, because we know the parents were fighting about all kinds of appointments. There seems to be our proper cause or change in circumstances. It just keeps percolating up. We know there is joint legal custody. So shouldn't we just kind of expedite it and say, do the best interest analysis? Is that problematic? I guess is my shorthand problematic, counsel?
I don't think it's necessarily problematic as long as this court was clear. We're finding that proper cause did exist and that the ECE was with both parents. I do think that all of those steps need to be fulfilled.
Right. Okay. This was just a little different because it was legal only. Right? I mean, usually they're part and parcel, but the trial court didn't touch physical, correct?
That's correct.
Okay. All right.
Make sure that the kid got medical care.
Right. Yeah, that was, okay. Thank you for indulging my question. I don't know if my colleagues have questions.
No, I don't have.
I don't have any questions.
And I don't have anything else to say, Your Honors.
Awesome.
Very much.
Thanks for being here today. This matter will be submitted. And then moving on to number 22 on the docket, which is docket number 373036, in Ray Z. Keller Minor. Looks like Mr. Ambrose has waived oral argument, so that matter will be submitted on the briefs. As well as, while we'll take up 23, which is docket number 375032 in Ray Henry Minors. And we do have counsel for one of the respondents in that matter. Good afternoon.
Gonna say, did we officially move over to afternoon?
We did.
All right, good afternoon, Your Honor. May it please the court, Hillary Krill on behalf of appellant mother Melissa Faulkner. This is a termination of parental rights case. This is a maybe somewhat unusual to the typical termination in that reunification was ordered. There was really great progress towards addressing all the barriers to reunification, and reunification with the kids was ordered and recommended in April of 2024. The only reason that didn't happen was for two circumstances, one being the lack of childcare. And that was just a matter of logistics, that there needed to be a wait list and, time needed to happen to get that in place. So as being very proactive for the children, that reunification was delayed. And then there was the break-in of the father at the house that really unraveled this case.
And mom's failure to get a PPO after it happened.
So that was actually contested. She did take actions to do that. There was issues with service that kind of delayed the full effectuation of that PPO. But there were efforts in place to file that police report and do that PPO, albeit in the trial court's opinion, not quickly enough.
Yeah, that really bothers me because she knows when she's safe and she knows whether or not filing a PPO could put her in a much worse, and the children in a much more dangerous situation.
Yeah.
But I don't know. That's my personal opinion. I guess it doesn't really apply here.
Yeah, unfortunately, and the evidence here did suggest that, with such a long history of domestic violence, the caseworker in this case did provide testimony that that can be a barrier of that longstanding relationship and history for a victim to have hesitancy to obtain and take legal action against their abuser. And this was the appellant's first opportunity to really do that. So, it is unfortunate to not be quicker on that, but there was certainly testimony presented that that was a very difficult thing for the victim of domestic violence to do without a lot of support in getting that PPO in place, either from her trial counsel or from the agency to help her with that.
Wasn't there some, though, concern as well that mother was allowing father to reside in the basement, that it wasn't just a break-in? And how does that factor in here?
Yeah, thank you. That was actually a very big issue. And I hope the court does take the time to really look very closely at the facts. There was an initial testimony by the caseworker in the first review hearing after this break-in occurred. I believe the review hearing was within a month or so, or pretty close in time to when that supposed break-in happened. The statement about the father living in that house was very scant.
It came from one of the kids?
I'm sorry?
It was disclosed by one of the kids.
It was disclosed by the son, but there was nothing of him actually seeing his father there, seeing the belongings there, seeing anything that actually identified the father as living there. It was only that the son literally, quote unquote, believed he was there and that he smelled alcohol, which he associated with his father. So there were no belongings of his father. There was nothing. He didn't see his father. There was nothing associating his father with living there. And that was also supported by the caseworker doing a tour of the home and noting that there were no male belongings whatsoever in the home. In addition to saying that the basement was actually not suitable for someone to live in.
Wasn't, though, there also concern, regardless of whether that fact were true or not, that your client perhaps did not respond in a supportive way to a child who was very upset by his belief that his dad was there?
That was a concern that was raised, although in my review of the transcripts and what was put on the record, there was very, very little about that. Really, the only thing we have is the trial court saying that at some point she directed the appellant to believe the children and to listen to what they said. But that's actually doesn't appear anywhere on the record in an order or in a transcript. She just says it later in her oral opinion at the termination hearing that she made that direction, but yet there's no, we can't point to any place that she actually did give that direction. So do
you agree, though, that where there's a history of domestic violence and the children are frightened by one of the parents, that a custodial parent who either, disbelieves or disregards that child's articulation, that's problematic in terms of demonstrating that remaining with the parent with custody, that's safe for them.
That certainly is a concern, and I think all parents should be mindful of that trust and bond built with their child on that. I would just note that this case does appear to be distinguishable because we don't have evidence on the record of of the mom actually disbelieving the children. It's just a statement that was made along the way and got warped, like several other pieces of the testimony got warped over time. And I would also note that there was very critical testimony from the caseworker that the children's reaction to the break-in actually was a triggering event that caused them to say that the father was living there. So it was actually an instance of the break-in causing further harm for the children down the road, rather than a concern in fact that the father was living there.
Thank you.
I do want to just note briefly for the court that the theme to this appeal kind of across the board is that there were insufficient findings on the record or legal determinations on the record by the trial court. So
would you say that the court looked at these children and made findings for them individually, considering their significantly different circumstances?
I do believe that that's actually lacking in this case. And particularly when you go, if you go to the section on best interests in the oral opinion, it is very scant. There is only one line regarding the daughter, MH, that said that she misses her mom, and wants to see her mom, but that's changed over time. There is nothing else about the daughter in the opinion on best interests. So that is very problematic. Even the son, there's some discussion of his behavior and concerns. But unfortunately, there is more conclusory statements about what the son may have been feeling, rather than actual evidence about what he was feeling or the traumas and behaviors that he was exhibiting, which ties into the issue about the hearsay evidence that was presented. That's dispositive under the In re Lard case that was cited in the reply brief. So that's a main thing. And then certainly regarding the bond with the children, that did not appear whatsoever in the trial court's opinion, other than to say the mom loved her children, which is good to have, certainly, but there was nothing about the children's bond with her. And this is particularly interesting in this case when we have two very thorough trauma assessments that said the kids have strong attachments with their mother and that these attachments were actually beneficial and weighed in their favor, that the children had this strong attachment. So it's actually against the weight of the evidence, the trial court's brief findings about the bond and the best interests of the children. But to Your Honor's question, there is a lot lacking in the distinguishing between the two children in this case.
Can you help me a little? This is just for my own curiosity. Can you help me a little bit with the timeline in terms of mom's on track for reunification? Reunification is planned. Where in here then, tell me what happens in like the order of events, if you can. Daughter's perpetrated on in foster care. Mom has very confrontational interactions with DHS after that, DHHS. Father breaks in and we have the cat. How does this all, what's the order of events?
Yes, absolutely. I made a nice timeline for
Oh,
us
I
here.
love timelines. I love them.
So this case did start off with the petition in January of 2023. So that was our very start. And then I'll skip ahead. Reunification was recommended and ordered of April 2024. Okay. And then I will note before that was the trauma assessment of the children. So the trauma assessment occurred before reunification, but there was no action on the trauma assessments. So then reunification was April of 2024. The break-in by the father was early May of 2024. There was additional factual discrepancies about the father being in the home and things like that. That's all occurring in May. Then we have A notable hearing here is August 15th. So along the line, we're still working on the repercussions of that break-in from April through now August 15. That's another review hearing, and it's important to note that the caseworker and the lawyer guardian ad litem for the children both stated that the children were very clearly bonded to mother and both supported reunification at that time. So reunification was still the goal. In September 2024, we have mother receiving her certificate to be a nurse and began employment there. And then in November 2024 is when we finally have a motion to change the son's counselor. So that came first. And that was based on it appears to be the same counselor for the whole time, but it appears that counselor was never effective in actually handling the child's behaviors and couldn't.
Wasn't the counselor like not even, was like in training or something like a?
That was for the daughter,
Oh,
actually.
okay.
Yeah.
Okay.
So at the same time, the daughter had counseling through, I believe it was called Second Story, and it was an intern that she was with. So that intern was not versed in any, sexual trauma or even the sexual abuse that she experienced. So first, the son's counselor was changed through a motion, and then on November 19th was the final permanency planning hearing, and it was only raised at that hearing regarding the daughter's counseling. So it's now unclear, since the petition to terminate was filed after that, it's unclear if the daughter ever even changed counselors after that was identified that she was working with the intern. So it's unclear if she's ever even received appropriate counseling since that time or even before that time. So again, just to highlight that November was when the children's counselors were finally addressed. And this whole time, nothing with the daughters, the sexual inappropriate touching, that was never addressed at all, except maybe now with this change of counselors, but even then it's unclear. And then the petition to terminate was filed a month later in December of 2024. Does that help with the timeline, or can I fill in any other gaps? Okay, thank you. So that is important. As I mentioned, the best interest in the bond to mother is very important here. That was not adequately addressed or discussed by the trial court. I highlighted for the court the dispositive issue about the hearsay evidence. And then the final category is that's truly dispositive here is the reasonable efforts and services provided. And with the discussion with the children's counselors, that's a main point of that argument, that the children themselves never received appropriate counseling.
Did counsel on the record make a motion to change the service plan?
Counsel did not, but the appellant had repeatedly asked her counsel about changing counselors and had brought it up to the caseworkers to particularly change the daughters once she learned of the sexual inappropriateness.
I know, but I'm sorry, I thought you were going into your argument that that reasonable efforts needed to be adjusted.
Yes.
Because new circumstances arose. That's what I was referring to. I'm sorry, I thought that's what you were dovetailing into.
Yes, I was actually getting there, so I appreciate that. So it wasn't directly through a motion or anything like that, but trial counsel did raise the sufficiency of the efforts on the record, particularly asking the caseworker about additional services for, hands-on visits, or a hands-on visit coach, about potentially seeing the children for separate visitations so that we could see the children's behavior separately, and some other type of services, particular programs that trial counsel maybe thought would benefit the mother. So he was asking the caseworker that through testimony. So that's how that was raised in the lower court.
But they didn't make a motion requesting a change in services?
Correct. There was no formal motion for that.
Any other questions?
No.
Anything else you want to add before we say farewell? Have a good lunch.
Thank you. Oh, the only other thing to add was that the appellant had asked for services, additional services throughout, but the caseworkers repeatedly declined and said on the record that the only services she needed was to continue with the domestic violence services. So there was a request for that and it was not made and was indicated that was not needed. So thank
Okay,
you.
thank you very much, counsel. This matter will be submitted. Appreciate
job.
your time.
Thanks for coming today.
We're now up to item number 24, docket number 373558, In re H.J. Peace Minor. No attorney is endorsed, and so that matter will be submitted on brief, leaving us with item number 25 on the docket. And there are two matters that are consolidated, docket number 373964 and 373965, In re Jobson Minors. And there too, it would appear that no one is endorsed for argument. And so we will submit on the briefs that matter as well, concluding today's call. So we are adjourned.